Please all rise for the arrival of the Senate President and the Senators.
The continuation of the impeachment trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order. We shall be led in prayer by the distinguished Senator from Aurora, Senator Edgardo J. Angara.
Lord, we convene here in search of truth and justice. May wrongs be made right through the legitimate processes of law, not through men who in their folly think they can wield it. May fairness never be sacrificed in our search for what is just and true. Remind us, Lord, that we would have to live with the decisions we make long after this court has adjourned, and our country would have to live with its decisions long after we have gone. May the legacy we leave not be of rancor, but of unity. And with one mind and heart, may we rebuild our nation based on genuine justice and equity. Amen.
Amen. The Secretary will please call the roll of members.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon Ejercito Estrada, Escudero Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Usmeña, Pangilinan, Pimentel, Recto, Revillas, Soto, Trillanes, Villar, the Senate President.
22 Senator Judges being present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms may now make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
The Secretary will please call the case.
Mr. President, before the Secretary does so, yes, Mr. President, may I move that we dispense with the reading of the February 22, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 22, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will now call the case.
Case number 0022011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances, Majority Floor Leader.
Yes, for the prosecution, Mr. President.
Good afternoon, Mr. President. For the prosecution panel of the House of Representatives, same appearances.
Noted. This defense.
For the defense, Your Honor, the same appearance.
Noted.
Mr. President.
Majority Floor Leader.
Mr. President, before the business for the day, which is the continuation of the cross-examination of the witness, may we recognize Senator Joker Arroyo for a manifestation.
The gentleman from Makati and Bicol has the floor.
Thank you, Mr. President. Just a cautionary note. Yesterday, I asked the prosecution whether Attorney Manuel, what's the following middle name? Marlon Manuel is the lawyer of the
Palea.
Palea. Well, I asked, yes, anyone can answer it. He's not, I'm not going, he's not inquisitorial.
Yes, Your Honor. Attorney Manuel is here, Your Honor.
No, I'm asking whether he is the lawyer of PAL, because you were you enlisted his help.
We will, Your Honor, the lead one of the prosecutors of Article 3, Your Honor, Representative Kakabag, will be able to answer your query, Your Honor.
No. My question is that there was the lawyer who appeared for the first time
Yes, Your Honor.
to ask questions on Article 3.
Yes, Your Honor.
More particularly when Mr. Javier of PAL took the witness stand.
Yes, Your Honor.
So my question is whether that lawyer, whom I remember as Attorney
Marlon Manuel, Your Honor.
Marlon Manuel, is a lawyer of Palea.
Frankly, Your Honor, I personally don't know the answer. That's Article 3. So we're asking Prosecutor Kakabag.
I'm not talking about Article 3. That's why I said this is a cautionary note.
Yes, Your Honor.
And I will say it now so that
Thank you, Your Honor.
I have been told by some respectable officials in the Department of Labor, of course confidentially, that, this proceedings is being watched because it's national TV. Oh, he's here. Is he not the one?
Yes, Congresswoman Kakabag, Your Honor. Marlon Manuel, Your Honor.
No, you better ask him. I mean,
Yes, Your Honor.
You ask him now. I'm just all going to ask, but that's a simple question.
Presiding Officer, Mr. Marlon Manuel, Your Honor.
No, the question is whether he is the lawyer.
Yes, Your Honor. He's a lawyer for
All right. Now, you see, the prosecution asked for subpoena, dus tecum, and whatever. It's now tongue twisting, for the Supreme Court to produce and for some officers to testify on the PAL case versus, involving the labor union, pass up. Now, the Supreme Court filed a return saying, in effect, that we cannot do it because the case is pending. And also because there are some confidential matters which cannot be disclosed.
Yes, sir.
Okay. Now, when you retain private counsel, perhaps it would be better part of discretion that you do not enlist lawyers who have vested interests, who have interests other than prosecuting the case. If the Supreme Court brought the documents, then the lawyer of the labor union against PAL will see it, while PAL will not have access to it. That is what I am saying. I've been in the prosecution. Before we retain lawyers, we screen them. And I think you have been doing that. But in this case, we accept, subject to the objection of the defense, any subpoena, application for subpoena. So we do it and produce it if the subject agrees. So I'm just making a cautionary note because we don't know whether we are on the home stretch or we'll still go a long way. But that, in the case of lawyers being retained by the prosecution, please screen them so that there will be no statements or suspicions. That is all. I'm not going to say that you have been remiss, because perhaps that's oversight. But please be careful next time.
Your Honor,
Thank
may I
you.
explain?
Go ahead.
This is not an oversight, Your Honor. First, let me tell this honorable court that Attorney Marlon Manuel is not a counsel for FASAP. He is a counsel for PALEA, and those are two different labor unions. FASAP has its own set of lawyers, and PALEA is not involved in this case. Second, Your Honor, we are very conscious of that fact. In fact, when we invited lawyers to be part of the prosecution team, we are very mindful of all these considerations. But we don't see any conflict in terms of Attorney Marlon Manuel being part of the prosecution specifically to handle Article 3 of this impeachment complaint.
You don't see it, but I see it. Because that's an obscurantist position. The fact is that Attorney Manuel's position is hostile to PAL, whatever the case is. So please be careful next time. Thank you.
PALEA is Philippine Airlines Employees Association.
Yes, Your Honor.
Yeah, and the FASAP is Flight Attendants
And Stewards Association
Steward,
of the Philippines.
Steward
Your Honor.
Association
Yes,
of the
Your Honor.
Philippines. They have no affiliation.
No, Your Honor.
So, Majority Floor Leader.
Thank you. Mr. President, may we now continue with the cross-examination of witness Secretary Laila De Lima?
May we request the good Secretary of Justice to come to the witness stand and testify under the same mode cross-examination. Thank you, Madam Secretary. The Defense Counsel has the floor.
Thank you, Your Honor. And with the kind permission of the Honorable Court, may we be allowed to proceed, Your Honor?
Proceed.
Good afternoon, Madam Secretary.
Good afternoon, sir.
Now, yesterday you dealt very lengthily on the dissenting opinion of the Honorable Justice Sereno.
Yes, Your Honor.
Right. And in the course of your testimony, you dealt on a lot of alleged infirmities or irregularities in the matter of issuing the restraining order involved in the case decided by them.
Yes, sir. Not just the issuance, but also the legal status or efficacy of the TRO.
And would you be kind enough, with the permission of the Honorable Court, to kindly state again those infirmities that you found in the dissenting opinion of the Honorable Justice Sereno?
Yes, sir. But in doing so, can I also have the copies of the resolution, of the dissenting opinions?
You may refer to
Thank
the
you.
dissenting opinion.
I beg your indulgence, it might be a little lengthy, and I thank you for your question, sir, to provide me or give me an opportunity to further expound on what I was talking about yesterday. Clearly, the November 15 TRO was conditional because there were 3 conditions stated therein. So at the time that it was issued, that was before 6 o'clock in the evening of November 15, there has been no compliance yet. Not even with respect to the payment of the bond, and even with respect to the appointment of legal representative with the corresponding SPA. But it was issued even before that. Clearly conditional TRO. But it was made to appear that it was already immediately executory. And that is why in the evening of the same day, the former president wanted to leave. So it was announced by the spokesperson that there is this TRO, the former president could already leave. Now,
That's one.
that's one.
All right. The second one is?
Because the spokesperson had the apparent authority from the Chief Justice to already to already announce those things. The next,
No, but I'm referring, with your permission, Madam Secretary, I was referring to the alleged infirmity or irregularity that you pick up from the dissenting opinion of the Honorable Sereno.
yes, Your Honor, I'm just laying down this thing so that it will be clearer. November 18, they met again. Now, remember, November 18 is a Friday, or was a Friday, and they don't ordinarily hold a hearing or a session. But it was called precisely to tackle the matter about the non-implementation of the TRO, because since the TRO was not honored by us on account of the reasons that I stated yesterday, the no formal notice yet as of November 15, and no compliance yet with the 3 conditions. They had to tackle that immediately on November 18, and there was this special session on a Friday. Now, it would appear, Your Honors, from the letter of Justice Carpio to the Chief Justice that the very important points discussed on November 18 were never reflected in the November 18 resolution, which was also immediately released on the same day. And that is why there wasn't again announcement that the former president would be leaving, would try to leave again the country.
No, may I interrupt you, Madam Secretary?
Yes, Your Honor.
I am only asking you about the various enumerations that you stated you found in the dissenting opinion of Justice Sereno. I'm not asking for an explanation, Your Honor.
May I beg your indulgence, sir, and Your Honor, that for a clearer picture, I need to say first this, to narrate first these things.
Well, the picture is very clear to us. All we wanted to know is what are those alleged infirmities that you found based on the dissenting opinion of the Honorable Justice Sereno. We will ask you about your explanation and probably about your justification if we need it. But in the meanwhile, we are limiting ourselves to the infirmities, alleged infirmities and irregularities, which you said you found in the dissenting opinion of the Honorable Justice Sereno. One of them is, as you mentioned, there was a TRO issued even.
This is a conditional TRO, but it was made to appear that it could already be implemented on November 15.
The second one is?
The second one is the exact voting and the matters voted upon on November 18 were not duly reflected in November 18.
And the third one is?
The third is they wanted to issue, well, because of that, Justice Carpio asked for a clarificatory resolution in order to clarify the November 18 resolution, because it was never stated in the November 18 resolution that there was no compliance yet of the conditions, and that it is not deemed, so it is deemed suspended until compliance with the condition.
No, with your permission, I'm not referring to the dissenting opinion of Justice Carpio. I'm limiting myself to the dissenting opinion of the Honorable Justice Sereno. So the third one is?
Let me just answer you, sir. That matter was reflected in the dissenting opinion of Justice Sereno. In fact,
So
Justice Sereno quoted verbatim the letter of Justice Carpio.
So that's the third one.
Yes, sir.
Is there any other infirmity that you discovered upon a perusal of the dissenting opinion of the Honorable Justice Sereno?
Yes, sir. The supposed clarificatory resolution of November 18, the clarificatory of November 22, as assigned to Justice Velasco for the drafting. And again, Justice Carpio noted that instead of clarifying the exact voting and matters voted upon on November 18, it only served to compound the error because the Chief Justice produced his own version of the November 22 clarificatory resolution, which did not reflect the correct voting.
Be that as it may, Madam Secretary, are there other observations that you discovered in that alleged dissenting opinion of the Honorable Justice
Yes, sir.
Sereno?
Yes, sir. The attempt to suppress, or the suppression, in fact, of the December 2 dissenting opinion of Justice Sereno.
I see. And what else? If there are any, nothing more?
There are more.
All right.
If only I have the opportunity to really explain.
You're not
everything.
prepared to deal with them as of today.
I can deal with them.
Please do so, with the permission of the Honorable Judge.
Proceed, Madam Secretary.
Well, as I was saying,
Mr. President,
Yes.
may I request that the witness be given a couple of minutes to go over the thick dissenting opinion to which the distinguished defense counsel refers and on which the defense counsel bases his question.
I'll have no objection, Your Honor, if a request to that effect is made, Your Honor. But I was on the assumption that the brilliant Secretary of Justice, Your Honor, is very much in a position to go ahead or proceed with her testimony.
The Madam Secretary will request it. I will give her all the time.
Thank you, Mr. President.
thank you, sir. Thank you, Your Honor.
How many minutes do you need to?
2 minutes, Your Honor.
You have 5 minutes.
Thank you.
Trial suspended for 5 minutes.
Long minutes, Your Honor, or Senate's minute?
5 minutes. Yung aking maid si Bing. Binisin mo lang ito. Binisin mo.
You're now ready, Madam Secretary. The Honorable Secretary, Your Honor, is now ready to proceed.
Trial resume.
Thank you, Your Honor. Another questionable or irregular act on the part of the respondent, Chief Justice Corona, is the failure to correct all the misleading and inaccurate disclosures of the spokesperson, including the misrepresentation that the voting was 9-4 when in fact it was 7-6, including the misrepresentation that as of November 15 and even as of November 18, the TRO was not yet effective.
This is on the basis of your examination or reading of the dissenting opinion of the Honorable Justice Sereno.
The Honorable Justice Sereno and Justice Carpio. Yes,
No,
sir.
I'm
Yes,
not,
sir.
I'm limiting myself only to Justice
Yes, sir.
Sereno's dissenting.
Yes,
Anything
sir.
more? Something that is substantial.
These are very substantial,
Yes, Your Honor.
especially the changing of the draft from the drafter of the November 22, the alteration of the draft of the November 22 resolution from the statement that there was no compliance of the conditions of the conditional TRO to there was substantial compliance with the conditions of
Now-
the conditional TRO.
Are you now?
Yes, sir.
My understanding based from your answer,
Just to clarify, who was the drafter?
It
Madam
was,
Secretary.
it was assigned, Your Honor, to Justice Velasco. by Chief Justice
And
Corona.
he drafted the resolution.
He drafted the November 22 resolution.
And
Yes, Your
there were changes.
Yes, Your Honor.
May I now proceed, Your Honor?
Proceed,
Thank you, Your Honor. Now, based on your answer now, I gather the impression that all the matters you stated a while ago came from your perusal or reading of Justice Sereno's dissenting opinion.
Yes, sir.
Yes, sir. So much that they are not from your own personal knowledge.
Yes, sir. I'm not a member of the court.
In other words, what you have told us, insofar as you are concerned, are merely purely hearsay, because they do not come from your own personal knowledge.
Objection,
Am I
Mr. President.
What is the ground for-
The
Just a
question
minute,
is misleading.
What
The dissenting opinion is a matter of judicial notice. In fact, we have marked this dissenting opinion as an exhibit for the prosecution.
That is not the subject of the examination, Your Honor.
The question...
Go ahead, please. I'm sorry.
The question, Mr. President, the question is leading in form, but misleading in substance. Because the question is, all that you have said or what you have testified to is hearsay, which is not so. It's misleading because as she testified, and as the question called for, she was reading from the dissenting opinion, which, as I said, is a matter of judicial notice.
That is precisely the basis of my question, Your Honor. What the witness told the court is merely what she gathered from the dissenting opinion and not from her own personal knowledge.
The Secretary may answer.
Secretary.
Go ahead.
Based on an official document
All right.
officially released to the parties.
I would like to clarify the reason for this ruling so that the people will not misunderstand, because we are dealing with technical rules with rules of evidence. The Secretary indeed read the dissenting opinion, and by reading that dissenting opinion, he has knowledge of the facts stated in that dissenting opinion. But to the extent of the truth or falsity of what has been stated in that dissenting opinion, if there is any falsehood, is hearsay. Because as far as the witness is concerned, because she is not present in the proceedings of the Supreme Court. So that's why I allowed the Secretary to answer.
Mr. President, I only objected to the use of the word hearsay.
Yes.
I objected to it because...
Sa Tagalog, hindi galing sa inyong sariling kaalaman.
Hindi.
Because you said hearsay, so I'm elucidating on that.
No, I just objected. Tumutol po ako, Ginoong Pangulo, dun sa paggamit ng kagalang-galang na pagtanggol ng salitang hearsay, sapagkat ang hearsay po ay may kahulugan sa ngayon sa ating rules of evidence.
Naintindihan po ng presiding officer yan.
Okay.
Pero ang ating testigo dito ay hindi pangkaraniwang testigo. Siya ay tanyag na abogado. Alam niya ang ibig sabihin ng hearsay at intelihenteng testigo ang ating kalihim. Pwede niyang sagutin yun. Kaya ang ruling ng presiding officer, she must answer.
Tinatago po namin yun, Ginoong Pangulo.
May we be allowed to proceed, Your Honor?
Proceed.
All right. Now, you also made us understand that the basis of the information you revealed to this honorable court on the issue of alleged infirmity or irregularity is solely on the basis of the dissenting opinion of Justice Sereno. Am I right?
On the basis of the dissenting opinions, not just of Justice Sereno, but of Justice Carpio, sir.
You are referring to the dissenting opinion of Justice Carpio?
Yes, sir.
I have read the dissenting opinion of Justice Carpio, and Justice Carpio never mentioned about the dates you had mentioned. For instance, the schedule or argument, the deliberation made, the voting, and so on. dissent is solely on the basis of the character of the conditions imposed. According to him, since they were not complied with, then the restraining order should not be made effective or enforceable. Am I not right?
Yes.
All right. There is nothing in his dissenting opinion which deals with the matters dealt with in the dissenting opinion of Justice Sereno, as you have narrated to this court.
For the defense, I think, to be fair to the witness, if you have the dissenting opinion of Justice Carpio, this is an effort to confront the witness, then I think it's only fair that the document, as a basis of confrontation, must be shown to her.
I would have done that, Your Honor, but I was given the impression that the Honorable Secretary of Justice had them in her possession, Your Honor.
I have a copy, Your Honor.
All right.
She had
The Secretary may answer.
Will you kindly indicate that particular portion in the dissenting opinion of the Honorable Justice Carpio dealing with the date you mentioned, the irregularity and the infirmity, which was the subject of his dissent?
Not on
Witness examining.
Yes, sir. Not on those matters directly, because as you correctly stated, sir, his dissenting opinion primarily delved on the character of the TRO. But there is also a portion towards the end of his dissenting opinion about the issuance of the TRO that was issued or released to the petitioners before 6 o'clock in the evening of November 15, even before petitioners' compliance with the first two conditions.
So there is nothing mentioned there about the alleged deliberation, the lack of oral argument, the lack of notice, and so on.
It's not in the dissent of Justice
I am very
Carpio.
sure that you must have also gone over the dissenting opinion of the Honorable Sinuisa. Reyes, the other dissenter. You must have gone over his dissenting opinion also.
For the November, is it the December 13?
With respect to the grant of the restraining order,
Yes,
which
sir.
was the subject of, and
Yes.
I have examined it. Will you kindly go over it and tell us in what particular portion of that dissenting opinion had the dates, the lack of notice, and the irregularities you mentioned before the court were incorporated? Because I do not find any for your information, Madam Secretary.
There is none, there is none, sir, because the dissenting opinion of Justice Reyes is the dissenting opinion of November 15, or the dissenting opinion to the TRO itself, where the very issue on the legal status or efficacy was not yet there, because we don't have the facts yet,
So
the inside facts.
I'm sorry.
Yes, sir.
So the basis of his dissent is that if the court acts on the application for the restraining order, one way or the other, it will render moot and academic the principal issue in this case. That is the substance of his dissent.
Yes, sir.
All right, thank you. Now, if that is so, why have you laid too much an emphasis on the dissenting opinion of the Honorable Justice Sereno? Will you kindly tell the Honorable Court the reason for your giving too much emphasis and why you highly gravitate on that dissenting opinion?
I'll gladly do that, sir. I have given importance, or I'm highlighting the dissenting opinion of Justice Sereno, not because of the discussion there on the merits of his dissent to the grant of the TRO. It's not actually about being the dissenting opinion, or it's not the dissenting opinion per se, but on the various disclosures or revelations that she had made, which gave us the picture of the irregularities that were committed within the court, insofar as the issuance of the TRO, as well as the interpretation of the legal status or effect of the TRO.
Thank you. And these matters are now pending consideration before the Honorable Supreme Court.
The main petition.
Correct.
Sir, yes.
Together with the alleged errors or irregularities attendant to the grant of the restraining order. Am I right?
I'm not sure if it's still being discussed or being deliberated upon by the Supreme Court. The alleged irregularities.
I'm telling you now that it is one of the issues involved in that case, which, and it is because of the citation against the Honorable Secretary of Justice for contempt for having violated the order of the Honorable Supreme Court in connection with the grant of a restraining order. Am I not correct?
In a sense, sir, yes, you're correct.
In what sense am I wrong?
Well, because if you are referring, sir, to my compliance to the show cause order, and the grounds I cited there is, number one, the lack of notice, and number two, it's a conditional TRO. Then the irregularities within the Supreme Court on the interpretation of the legal status, well, would not really have much bearing on the issue of my non-compliance. Because in the first place, when I submitted my compliance of the show cause order, I wasn't aware yet of those irregularities.
Correct.
Until I saw the dissenting opinion,
That is
December
correct.
13, of Justice Sereno.
And it is, and that was why I asked you the question whether, without having come across with the dissenting opinion of Justice Sereno, you would not have known all these irregularities that you mentioned in your direct examination.
Yes, sir.
All right, thank you. Now, apparently, you gave us the impression, and this honorable court, that permit the language, that you swallowed hook, line, and sinker the truth of what is alleged or incorporated in that dissenting opinion. Am I right or I'm wrong?
I'm giving it credence, serious credence, because it was never disputed or denied by any other member of the court.
But it remains to be a dissenting opinion up to now, unless modified or reversed by the Supreme Court in the final adjudication of the case.
It is a dissenting opinion on the very issue at hand, which is the issuance of the TRO or the propriety of the TRO. But it is not an ordinary dissenting opinion because it dwells on those other matters.
And it almost exempts you from criminal liability for being declared or being asked to show cause. Why should not be punished for contempt?
That is your interpretation, sir.
Yes, it saves you from the trouble of being made liable for having allegedly disobeyed the order of the Honorable Supreme Court, because there is school, and also the rejoinder that she made for not having been able to answer the issues raised in the dissenting opinion of Justice
Rejoinder
Sereno.
of whom?
Pardon, Your Honor.
Rejoinder of whom?
By Justice Velasco, Your Honor, the ponente of the case. Now, may I be permitted to go another? In that case, Your Honor, I will move, much to my regret, for the striking out or the entirety of the testimony of the witness on the ground that the same is hearsay, insofar as the accuracy, the truth, and alleged authenticity of what is alleged as basic facts on the, for the dissenting opinion, Your Honor. I regret to do that, Your Honor, but the rules of evidence and procedures compel me to do so. Yeah. I am not questioning that there is such a dissenting opinion, but I am not in conformity with it, with what was stated in there, together with the statement of facts made, because they are controverted by the other facts obtaining in this case, Your Honor.
What's the point? Yes, Mr. President, we'd like to be heard. As I understand it, the defense counsel is moving to strike the testimony of the witness on the ground that his testimony is hearsay.
No, only
the court.
No, no.
Yes.
May I only?
I think the counsel is saying that to the extent that of what Justice Sereno said in her dissenting opinion, that is the matter that is being covered by the motion of the counsel for the defense.
In other words,
As far as the dissenting opinion of Justice Sereno is concerned, as far as what she said in her dissenting opinion, that is within the competence of the witness to state in her answers to the questions of the defense counsel.
in other words, the basis of the motion to strike or the object of the motion to strike is the portion of the testimony of the witness on the irregularities.
To the extent of the
Yes.
truth
Yes,
or falsity
yes.
of what was said
And this is
by Justice Sereno in her dissenting opinion. But as far as what Justice Sereno said in her dissenting opinion, it stays into the record as a part of the testimony of the witness.
Yes. We vigorously object to the motion, Mr. President. Firstly, because the dissenting opinion is in fact a matter of judicial notice.
That's correct.
Yeah.
Well,
And,
anyway,
and the
there-
facts and
Proceed.
the facts that are therein stated in regard to the irregularities are part of the opinion of are part of the dissenting opinion. Firstly, Mr. President, these portions of the dissenting opinion are matters stated in opinion by a public official. Therefore, unless proven otherwise, they are entitled to a presumption of truth
I will-
and regularity.
I'll posit
May I finish?
I'll
this?
posit the question this way. No?
Yeah.
Whether what the witness said as irregular or not, irregular is indeed irregular, they want to be stricken off the record. But as far as the dissenting opinion of Justice Sereno is concerned, what she stated in that dissenting opinion will remain in the record as a part of the testimony of the witness. Am I correct in understanding
That's correct, Your Honor.
position?
We are not in any way disputing the existence of the dissenting opinion, together with what is stated
In other
there.
words, the counsel for the defense said to the court, please disregard the claim of the irregularity attributed to others by the dissenting opinion of Justice Sereno, because the witness was not present when those acts were done. And when they came to the knowledge of Justice Sereno?
Well, in which case, Mr. President, these statements in the minority opinion, apart from the fact that they are entitled to the presumption of truth and regularity, the fact is that those statements are in their own right independently relevant statements made by a justice of the Supreme Court who herself was speaking of their own personal knowledge. Now, secondly,
this is sufficiently argued. The chair will make a ruling unless a member of the Senate sitting as an impeachment court would want to discuss this matter.
But before the ruling of the Honorable Court, please, is made, may I be allowed 1 or 2 minutes,
I'm not finished.
Your Honor?
Let us allow the...
Mr. President, I'm not finished.
Yeah, let's allow the
No.
prosecutor to finish.
Secondly, it is plain to us that the motion is actually in substance raising an issue either of weight or defense. Now, whether it is a matter of weight or defense, Mr. President, it is not a ground to strike whatever portion of the testimony has been made. If it is a matter of weight, it is for the discretion of the court to decide on whether to give it weight, and if it's a matter of weight, how heavy the weight should be. And if it's a matter of defense, the defense will have its turn to present evidence to impeach, discredit, or overthrow the statements on irregularities contained in the minority opinion. Now, thirdly, Mr. President, I have read the concurring opinions myself, just like the defense counsel, and it is there, Mr. President, shown that these statements on irregularities or disclosures made by Justice Sereno were not treated or met in those concurring opinions. There was silence in their opinions. And we know that as in a court of justice, when such imputations are made, which are serious as against others, there is silence, there is a presumption of truth. I mean, as they say in Spanish, el que se no disputa, se acepta. If you do not dispute, you accept. The other justices never disputed in their concurring opinions these revelations made by Justice Sereno.
If the counsel is true, Your Honor, may I be allowed 1 minute rebuttal, Your Honor?
Just a minute. Is the gentleman from the prosecution true?
Yes, Mr. President.
The defense counsel.
If Your Honor, please, the Honorable Court would notice that we have predicated our motion to strike out on the basis of the admission made by the Honorable Secretary of Justice that she has no personal knowledge of all these irregularities and infirmities, and that this knowledge came to her rather, I'm sorry, by reason of going over the dissenting opinion.
By reading the dissenting opinion.
Correct, Your Honor. Yeah. That's why we made the statement that all she testified to in connection with the alleged irregularities or infirmities did not come from her own personal knowledge, but merely from a reading of the dissenting opinion.
That was accepted by the witness.
The presumption of regularity and the fact that the dissenting opinion exists, we never questioned that, Your Honor.
All right.
We never questioned that. We were limiting ourselves to the character of the evidence being elicited from the witness, Your Honor, which in accordance with the evidence and law is decidedly hearsay. And if it is hearsay, then it may be the subject of motion to strike out, Your Honor.
All right.
Mr. President.
Yes.
Mr. President, Senator Miriam Defensor Santiago wants to be recognized.
The gentle lady from Iloilo is recognized.
Before you make the ruling, Mr. President.
Mr. President, I'm responding to your call for the senator judges, if any, to make an input on this question before you issue your ruling. My first comment is this. Under the complaint, Article 7, the defendant is charged with betraying the public trust, and I'm reading now, quote, through his partiality in granting a TRO in favor of President and Mrs. and her husband, Jose Miguel Arroyo, etc. So the question under Article 7 simply is, did the Chief Justice show any partiality when the temporary restraining order was granted, not by the Chief Justice alone, but by his colleagues in the Supreme Court? That is the question today before us. Now, I have a copy of the internal rules of the Supreme Court. Rule 12 is entitled Voting Requirements and is self-explanatory, and Rule 13 is entitled Decision-Making Process. It appears from what the witness has said so far that she has never personally participated in either counting the votes or in the decision-making process of the Supreme Court. In fact, she has said she has no personal knowledge. She has admitted that. Now, according to the rules of court, Rule 130 and Rules of Admissibility, Section 36, testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his own personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. If she was absent, how could she have personal knowledge? What? She is in effect, therefore, offering to us her opinion. But I've already said several times in this session hall that no opinion is allowed by the rules of evidence unless the expert has first been qualified as an expert witness. She has not been so qualified. She was not present when these so-called irregularities or discrepancies were taking place. So how can she be a witness on this instance, on the particular point of fact of whether the Chief Justice took an active role in issuing the TRO all by himself, when, according to the witness herself, according to the internal rules of the Supreme Court, which are available to lawyers like us, no one justice is allowed to issue a TRO all by himself. So, defense is correct in invoking the hearsay rule. There are exceptions to the hearsay rule. There are 1 to 11 exceptions. Which of these exceptions is the prosecution trying to ground its position on? The general rule of evidence is no hearsay. Only eyewitness can testify except 1 to 11. Under what exception is being quoted? Why are we splitting hairs? It's very, very clear. A witness can only testify as to what he perceived himself, except that there are 11 of these exceptions, and none of them is being cited by the prosecution panel. So in effect, what we've been hearing is a series of opinions extrapolated or explained to us by the witness. But we have already seen that a witness is not allowed to express an opinion unless she has been qualified as an expert witness. And there are rules for qualifying her. Let me quote only one case, just one case, decided only this month, February 1, 2012, the case of Malayan Insurance Company v. Reyes. Here is the Supreme Court. Concomitantly, a witness may not testify on matters which he or she merely learned from others, either because said witness was told or read or heard those matters. Such testimony is considered hearsay and may not be received as proof of the truth of what the witness has learned. This is known as the hearsay rule. Maybe just one other case, Estrada v. Desierto, 2001. But notice that what I cited was a case issued only this month by the Supreme Court, educating all of us in the law profession and in the general public. Estrada versus Desierto. There are 3 reasons for excluding hearsay evidence. 1, absence of cross-examination. 2, absence of the manner evidence. And 3, absence of the oath. Now, we are talking, the witness insists that her opinions are well-grounded on the dissenting opinion of a singular justice of the Supreme Court. So we are now faced with the issue of what is the weight of a dissenting opinion. The Supreme Court itself said in the 2008 case concerning Mr. Amado Macasaet, quote, the Supreme Court stated that elementary decision-making teaches that we cite the majority opinion as president, not lonely dissenting opinions. Another case, 2006, Yes I.S. Vicapisanan. It is the majority opinion and not the dissenting opinion that is the controlling jurisprudence. These are accepted facts in law school. Why do we have to debate these topics? We can safely take them for granted. So to return to Article 7, our quest here is factual in nature. Was the Chief Justice personally and individually responsible for what are perceived deficiencies or irregularities in the issuance of the TRO? The TRO is a subject matter, and the target of this particular Article 7 is the Chief Justice, the respondent. The issue therefore is, can one judge be held liable for the decision of a collegial body? Here is the Supreme Court speaking in an administrative case filed by an individual against certain justices of the Supreme Court, and here is what the Supreme Court said. Although the Chief Justice is primus inter pares, first among equals, he cannot legally decide a case on his own because of the court's nature as a collegial body. Neither can the Chief Justice by himself overturn the decision of the court, whether by division or the en banc, whether by division or by the entire Supreme Court. And here is an excerpt from the book, Judicial Opinion Writing by Joyce George, in its 4th edition, as early as 1993. In writing an opinion, the writing judge is involved in a joint venture. The end product is not his opinion alone, but rather that of all the members of the panel who form the majority. So I return to the issue at hand. The issue at hand is simply like this. Is the witness qualified under the rules of court to testify on this particular matter? Answer no. She said no herself. She said, I'm not a member of the court. I've not been there. I was not present. I was just reading the opinion, the dissenting opinion of one of the dissenting justices. That's what she said. So she's not testifying according to her own personal knowledge. That falls under the hearsay rule. As I said, I admit that there are 11 exceptions to the hearsay rule. Therefore, prosecutor has the burden of showing that at least one of the 11 exceptions to the hearsay rule applies. Otherwise, there's no point belaboring this issue. We can move on. Let's move on, counsel. Thank you, Mr. President.
Thank you.
Mr. President, may I react to the distinguished lady senator and now international jurist?
Proceed.
Mr. President, point of order. He will engage in a colloquy with me, a judge. The judge has spoken. Now the judge is taking time to deliberate on what she has just told the court. I don't think this is proper.
Counsel,
you should debate among yourselves. You do not debate with a judge.
Yeah, counsel, I'm sorry. A member of the court objects to any further discussion. So
Yes,
I will make a ruling.
Mr. President, may I just have, may I just add for 2 minutes a remark? Well, one of the exceptions to the hearsay rule, one of the 11 exceptions to the hearsay rule under Rule 130 is Section 44.
And which says?
Yes, let me read that. Yeah. It says, Section 44 of Rule 130, one of the 11 exceptions to the hearsay rule. And it says, quote, entries in official records. Entries in official records made in the performance of his duty by a public officer of the Philippines or by a person in the performance of a duty especially enjoined by law are prima facie evidence of the facts therein stated. This is an exception
Yes.
to the hearsay rule, and therefore the burden of persuasion is shifted. We have exercised our burden.
Mr.
because it's
President.
then the burden is shifted to the defense to demonstrate to the
May I
court
beg the
that we do
indulgence
not
of
fall
the
within
lady
this
senator
exception.
from
Yeah.
Iloilo to let the counsel finish, and then I will recognize her.
Thank you.
Yes. Proceed.
Yes, I'm finished with my statement.
That does not apply, counsel. Let me educate you. When an official custodian or other representative qualified by that office or authorized by that office to issue an official record does so, then the presumption applies that what is stated in the official record is correct. to that extent. Therefore, there is an exception to the hearsay rule. That person or that custodian or that record keeper does not have to explain why his record is that way. You just have to take it on faith. That is the meaning of that. But we are talking of a dissenting opinion by collegiate body, the Supreme Court. So, if the dissenting opinion contains certain narrations of fact, which in fact are intended to dispute what the majority opinion has issued, you cannot prima facie presume that the dissenting opinion is correct and the majority opinion is wrong. That's why I read you those cases where the Supreme Court repeatedly said, you rely on the majority opinion, not on the dissenting opinion. That is why I was warning you already, do not engage in a colloquy with the judge. That is not allowed by the rules of the impeachment court.
All right.
Put it in your memorandum.
All right. May the presiding officer now make a ruling? Is there any objection? All right. It is the ruling of the chair that to the extent of the facts narrated by the witness on the basis of the dissenting opinion, let them remain as a part of her testimony. Let them remain as a part of the record as a consequence and part of her testimony here as a witness. But to the extent of the truth or falsity of what the dissenting opinion of Justice Sereno contained, to the extent of those facts, whether they're true or not, that the Chief Justice influenced this or the Chief Justice did that or somebody else did something else, then to that extent it is hearsay because the witness was not present when those things were being done or being said. And so I will allow the testimony of the witness to remain into the record and admonish, or rather suggest to the court to disregard whether the statement of the Chief Justice or what he did or other justices did in the course of their deliberation, because those are not within the competence of the witness to testify on, so therefore those are hearsay.
Thank you, Your Honor. I was about to make a short manifestation, Your Honor, as to the effect of a declaration of statement being considered as hearsay.
Yes.
Because there are plenty of jurisprudence to the effect that whether objected to or not, if the testimony is hearsay, it shall not and must not be considered by the court in rendering a decision, Your Honor.
Yes, but we must remember that we are not trying a criminal case. We are trying an impeachment case. Although there is a penalty, the only penalty is not loss of freedom or infliction of an economic burden, but the removal of the respondent from his position and his disqualification. And therefore, the principle of the rule on hearsay, the hearsay rule contained in our rules of evidence, do not apply strictly in impeachment cases, as far as I could remember what I read about the experience of the United States in impeachment cases. It's true that in a strictly criminal case, the hearsay rule is a very strictly adhered to as a rule of evidence, but not in an impeachment case. And that's why I made the distinction between the truth or falsity of what was related by Justice Sereno in her dissenting opinion and what the witness now said based on what was contained or the information being presented to her on the basis of the dissenting opinion of Justice Sereno. To that extent, and to the extent of the dissenting opinion, let it stay as a part of the testimony of the witness. So ordered.
Now, I am heavily thankful, Your Honor, for the announcement made by the Honorable. But I'm also thankful for being allowed to make that manifestation of record, because that is a rule not only applicable to civil, criminal, and other cases, Your Honor. And I'm searching in vain a ruling or a rule of procedure insofar as the impeachment court is concerned relative to hearsay evidence. If we examine there is nothing in there, Your Honor.
Counsel, I'm going to ask you to read the book of Charles
On impeachment. Yeah.
The one written by
Black.
Charles Black.
Yes, Your Honor.
And also the book written by Raoul Berger of Harvard.
Yeah.
These two books will tell you that the hearsay rule is not adhered to strictly in impeachment cases.
Thank you, Your
If
Honor.
you want, I can bring them here. I think I have them in my office upstairs.
Yeah. I have gone over the first book, Black, Your Honor, but the second one, I have not seen it. I do not know. Thank you, but thank you for the information.
Raoul Berger is a Harvard man who wrote a very extensive study on impeachment trials in America. And he cited a lot of authorities to say that hearsay rule does not strictly apply in impeachment cases. And so I understand your position. The guilt or innocence, or the guilt respondent beyond reasonable doubt. We are going to decide this case on the basis of the quantum of evidence that we think is best to be used in determining whether he is guilty or not guilty, not beyond reasonable doubt. It is akin to a criminal case, but not really a criminal case. And that's why I made that ruling, and so let it remain.
I'm through with the witness. Thank you, Madam Secretary.
Thank you.
Thank
you, sir.
Okay.
President.
Let us now discharge the distinguished
President,
Secretary of Justice.
Mr. President, there are a number of senators made reservations to ask
Yes.
questions to the witness. So, move to suspend for 10 minutes, the 15 minutes of trial before we proceed.
All right. Madam Secretary, can you bear us out? Bear with us, rather. Okay. Trial suspended for 15 minutes.
Lacson, Miriam, Duilon. Lacson, Miriam, Deron, Legata. Lacson, Miriam, Frank.
Good afternoon. The trial is on a 15-minute break. We saw Senate President Juan Ponce Enrile make an important ruling on the testimony of Justice Secretary Laila De Lima. The defense moved that the testimony of De Lima be stricken out of the record, but Enrile ruled that it stays, but the matter on the falsity or truthfulness of the narration regarding the circumstances on the TRO, the alleged irregularities committed by Chief Justice Renato Corona, will be considered hearsay. It was crucial what the Senate President was saying because he was clarifying that the hearsay rule does not apply strictly in impeachment cases. He told lead defense counsel Serafin Cuevas that what we are trying is not a criminal case, it is something akin to a criminal case. So rules like the rules on hearsay evidence do not apply strictly here. It's important because in past weeks, the prosecution has been saying that it seems Enrile has been becoming very strict and conducting the trial in a manner as if it were a criminal trial. But now we see some clarification from Enrile that he views it as something akin, the impeachment case as something akin to a criminal trial, but not exactly the case. We saw Senator Miriam Defensor Santiago actually calling the testimony of Justice Secretary De Lima hearsay. She said that De Lima does not have personal knowledge, and the exception cited by the prosecution that it was a public record made by a public official does not apply. That was the argument of Prosecutor Raul Daza. But again, that was overruled, but with Enrile's ruling that the testimony stays. So earlier, we also saw the cross-examination of Secretary De Lima. She admitted that her sole basis for those alleged irregularities was a dissenting opinion of Justice Sereno. And she clarified that this issue on the alleged irregularities of the issuance of the TRO does not have any bearing on her alleged defiance of the TRO of the Supreme Court, because this was a point that Cuevas was trying to make in his cross-examination. So we will see this afternoon how we will proceed and eventually what the ruling of Senate President Enrile means, that the testimony stays on the record, but the falsity or truthfulness of that cannot be determined by the mere testimony of De Lima alone. We bring you the press conferences of the defense and prosecution teams.
We look at that, ang tingin namin doon ay personal na opinion pa lamang ng ating Senate President yon. Although hindi natin maalis na 23 sila, may kanya-kanya silang view, opinion, kung anong quantum of evidence. Pero kung mababalikan ko yung sinabi ng isa nating katunggali, ang magiting na prosecutor na sinabi sa atin na sa tingin nila, they have attained proof beyond reasonable doubt. Yun po ay binabalikan ko, ibig sabihin patunay na nire-recognize nila na ang quantum of evidence dito ay proof beyond reasonable doubt.
Sir, good afternoon po, si Richie from Manila Times. So, sir, ibig po bang sabihin na wala naman palang malaking naibigay na testimonya si Justice Secretary dahil binasa niya lang naman yung kanyang testimony doon sa dissenting opinion, at dahil nga sa decision ng impeachment court na strike out yung tungkol sa falsity or truthfulness ng kanyang opinion. So parang inulit niya lang doon sa impeachment court kung ano yung content ng dissenting opinion ni Justice Sereno.
Yung makikita natin dito, ang na-establish lang so far is that merong naging desisyon ang Korte Suprema na nagka-TRO doon nga sa travel, yung ban on dun sa travel dahil sa watchlist order under DOJ Circular 41 na hindi ito nagustuhan ng ating Secretary De Lima, no? So ang makikita pa lang natin dito, nagkaroon ng desisyon ng Korte Suprema at hindi nila naipakita dahil nga wala naman siya doon nung nag-deliberate ang mga justices na nagbigay ng desisyon, nagbotohan sila, merong majority opinion na nag-issue ng TRO, hindi na patunayan sa pagtestimonya ng ating Secretary de Lima na si Chief Justice Corona ang responsible kung bakit nagkaroon-garong TRO o kaya't na-impluwensyahan niya ibang mga justices na bumoto para magbigay ng TRO.
Dagan lamang doon, may kita natin dito na ang Senate as impeachment court, dahil nga pinresenta nilang testigo ang ating Secretary de Lima, ay paggalang ito. Dahil kung ordinaryo, sosgado yan, dahil it's part of judicial record, pwede yan, basahin na yan ng judge. And under the rules of court, ang tawag dyan, the court could take judicial notice. Dahil po this is part of the jurisprudence of the land. Pwede po yan kukunin na libro at babasahin po ang desisyon. Kaya lang nga po, dahil binibigyan ng paggalang ang ating secretary being part of the three branches of government, kaya po natin narinig ang kanyang testimonya ukol sa bagay na ito.
Sabi po ni Congressman Daza kanina, entitled to a presumption of truth daw yung facts sa dissenting opinion ni Justice Sereno. Unless proven otherwise, may way po ba kung paano patutunayan yun?
Alin ito yung sinabi ni
Congressman Daza po?
Ay itong entries made in unofficial records. Okay, presumption. Paliliwanag po natin yan, Makikita niyo po na tinukoy yan una ni Senator Miriam. Sabi niya kasi, magpakita naman kayo. Magpakita kayo ng bumabaksak ito sa isang exception. 11 po kasi ang exception. At ang tinukoy niyang exception is entries made on official records. It is prima facie evidence kung anong nilalaman ito. Tamang-tama po ang sinabi ni Senator Miriam. Ang exception pong iyon ay pumapasok lamang ukol sa kustodya ng dokumento. Kung ikaw po may hawak at meron pong entrada roon, prima facie evidence of the truth of the statements therein. Pero po hindi ito sumasaklaw sa isang court decision. Kasi po ang court decision, sabi nga niya, isang collegial decision. At ang dissenting opinion ay isa lamang parte ng isang desisyon ng mayorya. Yan po. Yes.
Kapag binabanggit si Justice Cuevas na natanong sa Secretary, meron bang branch ng government na...
lang po yung sinasabi ni Justice Cuevas kahapon na meron bang branch ng government na pwedeng magsabi kung tama o mali yung decision ng Supreme Court and Bank?
Well, yung tanong kasi, pinapakita lang dyan. Nakita natin kasi na hindi sinunod ni Secretary de Lima yung TRO na iginawad ng Korte Suprema. Hindi po ba? Hindi niya sinunod yan. So, kaya ho siya show cause ng Supreme Court, ng Korte Suprema, kung bakit hindi mo sinunod yung TRO na iginawad namin. Kaya yung tanong ni Justice Cuevas kahapon, meron pa bang ibang sa ngayon ng pamahalaan na maaaring mag-review sa Supreme Court? Sapagkat ang nakikita ho natin dito, meron na hong TRO na ginawad ng Supreme Court, ngunit yung Secretary of Justice, hindi niya ho sinunod yun. Ngunit, nakikita naman ho natin na doon sa testimonya niya kahapon, piniliwanag naman ho niya kung ano yung pananaw niya kung bakit hindi niya sinunod yung temporary restraining order.
At
Sa saligang batas natin, ang merong kapangyarihan na magtingin kung ano yung batas, ano yung sinasabi ng batas, at magdesisyon tungkol dito ay ang Korte Suprema. Ngayon, ang tanong mo kung meron bang karapatan ng ibang sangay ng gobyerno na i-review o aralin kung tama ang kanilang desisyon, wala na. Dahil yun yung trabaho o kapangyarihan ng Korte Suprema sa ilalim ng ating saligang batas. Pero, indirectly, merong kapangyarihan ang legislative na ma-review ang kanilang kapangyarihan na magdesisyon kung anong nakalagay sa batas by making their own law. So, ang gagawin ng legislative, kung ibig sabihin ay tingin nila hindi tama ang desisyon ng Korte Suprema dahil ang lahat ng desisyon ng Korte Suprema ay naayon sa batas, ang kailangan gawin ng legislatura ay palitan yung batas. Dahil ang kapangyarihan lang naman talaga ng Korte Suprema ay i-apply, tignan kung ano yung nasa batas at gawin at sundin ito.
Last two questions for the defense.
Regarding to na na-revealed si Atty. Marlon Manuel na abogado daw pala ng Palea, ano magiging effect nito sa impeachment court? Kasi hiwalay man yung Palea at yung PASAP, Pero ano maging epekto nito sa case ng PASAP sa Supreme Court na nakapending at maging epekto naman nito sa impeachment court at kung meron ba liability dito si Atty. Manuel sa pagtanggap bilang prosecutors?
Siguro yun dun sa usapin dun kay Atty. Manuel, pati kung ano yung meron ba siyang conflict o wala, hayaan na ho natin na sila ang magpaliwanag niyan sapagkat wala po kami sa depensa sa posisyon na magpaliwanag at kami naman po naniniwala na meron ho silang mga personal reasons for that and may mga justifiable reasons sila in that situation. So, be that as it may, nag-explain na ho yung prosecution. Kami naman po sa depensa, hinahayaan po namin sila sapagkat wala naman po talaga kaming kinalaman sa bagay na yan.
Karagdagan lamang, makikita ninyo na iyon ay tinanong ni Senator Arroyo. Ang gusto lang naman niya sigurong pakita ay may mga dokumento na dapat hindi nakikita na magkabilang panig. Kahit nasasabihin natin na itong dalawang organisasyon nito ay tumatayo sa interest na laban sa Philippine Airlines. Yan ang tinatawag natin na conflict of interest. Sa ngayon po, ayaw namin talakayin kung meron mang conflict of interest yan o wala. Ang importanteng makita natin na ito'y inangat lamang at titanong ni Senator Arroyo. Yan po. Ata yan. Yes, ma'am.
Sa sinabi po ni Attorney Dazan na since wala po nag-challenge sa opinion ni Justice Sereno, parang acceptance na rin po yun. Ano pong masasabi ninyo doon?
Okay. Ito po, ganito yan, ano? Hindi dun sa, with all due respect kay Congressman Daza, na sinasabi kung hindi na-challenge ay tumatayo ito. Makikita po natin na tingnan natin yung decision as a whole. The decision as a whole is a decision of the majority of the court. Yung pong dissenting opinion ay isa lamang or party lamang ng isang desisyon na bumubuo nito. Ang dissenting po ay hindi pinagbabawal. Ito po ay ginagalang dahil naniniwala, ito po ay patunay na ang bawat justice ng Supreme Court ay may sariling pag-iisip. Na kung hindi siya sang-ayon sa desisyon ng mayorya, pwede niyang ilatag sa separate opinion ang kanyang dissent. So, there's really nothing wrong with that, and that's not really an admission. Kasi po, hindi mababago kahit pa hindi kumibo ang fact na meron tayong majority decision. Opo, yun lamang po. Salamat po.
Thank you. Thank you. Prosecution briefing.
Today, I'm sorry, on Article 7, but we saw some light today with something that we'd always been arguing from the very beginning on the very nature of how and what an impeachment proceeding should be. The most ardent person who's been discussing it is no other than our Deputy Chief Prosecutor, Congressman Rudy Fariñas of the 1st District of Ilocos Norte. Apo, please.
Thank you, Miro. I'm very happy that what happened this afternoon, we could call it providential, na nag-object si Justice Cuevas, wanted to strike out the testimony of the Secretary of Justice, but the Senate President, for the first time, made it categorical that this is not a criminal trial. And that has been our position from day one. Nakita nyo naman, nung tamayo ako doon, na ang usapin lang po dito is just the matter of yung karapatan ng public officer to remain in office. So, di ba, nagkaroon nga ho kami ng palitan ng kuro-kuro noon, na sabi, meron naman penalty, removal from office. Yes, that's only the penalty attached to it. But after that, kasi pagkatapos po nito, ang usapin lang dito, meron ka ba bang karapatan na hawakan yung office na yan o wala? Pag nawala, tanggal na. Susunod na po yung criminal case doon. Kaya now, napakaganda po yung nangyari para sa amin.
Siguro, pandagdag na lang doon sa sinabi po ni Congressman Fariñas, we really look at this as a major victory insofar as the declaration of the court today, when finally the court took a specific stand on a matter that we had been raising from the very beginning, that this is not a criminal proceedings. And we have always objected to, and Congressman Fariñas on the floor has always been objecting to the fact that the decisions as they are being rendered in the past, particularly on excluding certain evidence and the manner by which evidence is presented, partakes of a criminal proceeding which we said should not. And no less than the Senate President has said on three matters. This is not a criminal proceeding. Secondly, hearsay is actually admissible in impeachment proceedings, which is what we've always been saying. No less than Congressman Fariñas has in fact been arguing that hearsay evidence is actually admissible except for uncorroborated hearsay evidence, meaning yung talagang walang ibang po pwedeng, siguro if you want.
More importantly, Miro, sinabi ni Senate President na hindi proof beyond reasonable doubt ang kailangan dito. So yan very clear na hindi in the nature of a criminal case. So maganda. What happened previously siguro is ito naman yung recovery namin. Nakita rin siguro ni Senate President na may right naman ang people of the Philippines, the House of Representatives, to due process. Ang due process po kasi magkabila yan. Hindi lang naman po doon sa pinapanagot ng taong bayan. Yung taong bayan, may karapatan din po sa wastong proseso. Kaya dapat po, din naman yung aming mga ebidensya at sana po ito'y tuloy-tuloy na pagbibigay sa amin ng karapatan namin para mapresenta yung aming kaso ng mabuti.
Ang isa pang magandang lumabas dito sa ating paglilitis ho, yung kahalagahan po ng dissenting opinion ni Justice Sereno po. Ang importansya po noon, meron kasing mga sinite siya na facts na wala po dun sa majority opinion. Na unang-una, i-isyong ex parte yung TRO. Ibig po sabihin ng ex parte, hindi binigyan po ng tsansa magpaliwanag ang gobyerno ng kaniyang panig. At pangalawa po, ay merong mga circumstances na pinag-usapan na hindi po natupad and yet pinalabas po ng Korte Suprema through Chief Justice Corona na epektibo na po yung TRO.
So, ulitin ko lang, no? 3 bagay ang tingin namin importante sa sinabi sa 2 minuto lamang na sinabi ni Senate President. That this is not a criminal proceeding and that based on U.S. jurisprudence, which is what we've always been saying, is that the quantum of evidence is not proof beyond reasonable doubt. In fact, it is just any proof which any of the judges are willing to accept to support a verdict of conviction or acquittal. It's entirely up to the senator to make that decision. There is no quantum of evidence that is actually required or set. And lastly is that hearsay is actually admissible in terms of impeachment cases. And very, very lastly, I see that third point on hearsay is that the prosecution today is left with no choice. Sometimes we have to find derivative ways to prove this case because the Supreme Court has made it very, very difficult. Ang Korte Suprema po ay naglagay po ng isang napakabigat na balakid para po natin makuha ang katotohanan. Unang pagkakataon, ang pag-i-issue ng TRO laban doon sa foreign accounts. Hindi po natin mabuksan po yan. Pangalawa pong balakid, yung February 14 ruling of the Supreme Court, nung sinabi po nila na hindi pwede any of the justices, none of the court personnel can go. They can voluntarily go. Una, hindi namin nire-respeto ang
Walang strike out. Sabi ni Senate President, let it remain on the record. Let it stay. And then bahala na yung mga individual senators na tignan, himayin kung alin doon ang kanilang papaniwalaan, alin doon ang kanyang narinig ng sa iba. Total, alam naman ng, maski ikaw, kung yung nagkukwento, marinig mo na hindi naman niya alam, pero Secretary of Justice ito. So, yung testimony niya was allowed to remain on the record. Walang in-strike out.
Dun sa dissenting opinion,
It was not stricken off the record. Malinaw yon. Sinabi ni, there was a move to strike it out, but it was not stricken out of the records because precisely, let it stand and let the senators just make the decision. Ano ba ito? Is that hearsay? And sinabi nga niya, even if it's hearsay, it's going to be admissible, but it will now depend on how the senators will appreciate it. Kaya nga sinasabi ni
the prosecution panel, if you will allow me to do a Senator Miriam. She was not present during the en banc deliberation. But if I may suggest, why don't you do it another way? Assuming that Justice Sereno, because we have already ruled unanimously not to issue a subpoena to any of the associate justices. That's for gone. Wala na po yun. But for all you know, she brought with her a clerk or her chief of staff, or whatever. Baka naman po present siya during the en banc, and she would have personal knowledge. Bakit hindi nyo naman alamin, and then submit a motion to the court na mag-issue ng subpoena to the person concerned, at baka mapayagan kayo. So at least, somebody, not Secretary De Lima, who has no personal knowledge on the contents or the truthfulness of what transpired during the en banc sessions, the 3 en banc sessions of the Supreme Court, baka naman makakuha kayo na may personal knowledge. It is just a suggestion.
Maganda po
just
sana
to ferret out the truth, no? Not for anything else.
Maganda po sana yan, Ginoong Sendor. Kanya lang, ang balakid ay ganito. Ang Korte Suprema, noong Valentine's Day, birthday ng ating Pangulo, naglabas ng isang resolusyon na kung saan ipinagbawal ng Korte Suprema na kahit na mayroong subpoena na manggagaling dito sa Senado, sa impeachment court, para sa isang maestrado o isang empleyado ng Korte Suprema na dito'y pumunta upang magbigay ng saysay. Ang sabi doon po sa resolusyon na yun, may mga bagay na internal, ang tawag ng Korte Suprema internal, na hindi pwedeng ibunyag kahit dito po sa impeachment court. At saklaw po riyan, hindi lamang isang maestrado, kundi ang kanyang mga empleyado. Ngayon, kung ibig o kagustuhan ng isang maestrado na sa kanyang ganang sarili ay pumunta rito at magsaysay, ang sabi po nung resolusyong yon, kailangan humingi ng waiver o clearance kung sa ating pangkaraniwang usapan sa husgado. Kanya hihingi ng waiver yung maestradong yon. Hindi
if I
po.
may, we're not there yet po, assuming that there's a memo issued even to the employees, not just an internal arrangement among the justices of the Supreme Court. Wala pa po tayo doon because it is up to the court, this court, to determine if when we ask questions or you ask and the defense panel will ask their questions, it is up to us to decide whether or not he or she can decline to answer the question.
Ginoong Senador, ang aking pong iniisip na talagang ang may personal knowledge dito is si Justice Sereno. Kanya nga po, yung
That's accepted po. Pero for all you know, hindi lang naman si Justice Sereno ang present doon. Baka meron siyang bit-bit na Supreme Court employee, one member of our staff, na pwede yung...
Saklaw po yung yung sa resolusyon ng Korte
Well,
Suprema.
I'll say it again.
Pati mga empleyado, saklaw dun sa
I'll say it
pagbabawal
again. This is an impeachment court. Sui generis po ito. Ito po supreme din on its own. Ano? Anyway, I'll not belabor the issue.
Baka po naman sa
pupunta na
sa
po
sariling kusa ni Justice Sereno dahil dito sa ating usaping ito, baka naman sa kanyang kusa ay humingi siya ng waiver at hari nawang mabigyan ng waiver o clearance ng Korte Suprema at dito magbigay ng kanyang
Anyway,
salaysay.
sir, that's just a side issue. I'll now proceed to my main issue. Tatanungin ko na po si Secretary De Lima.
Okay, maraming salamat po sa inyong payo. Susubukin po namin yan. Baka naman po maawa si Justice Sereno sa ngalan ng bayan na pumunta rito para magbigay ng kanyang sariling salaysay.
But if you're waiting for the impeachment court to issue subpoena, wala na po yun because we have unanimously supported the presiding officer that we will not issue a subpoena to any associate justice of the Supreme Court.
Alam po namin kanya po.
Now, Madam Witness, magandang hapon po.
Magandang hapon din po, Your Honor.
When did you first learn? Kailan niyo po unang-unang nalaman na mayroong TRO? Ayon po sa inyong salaysay, mga 1 o'clock ng hapon ng November 15. Tama po ba yan?
Opo, nung nag-press con po, sige.
Now, when did you first learn about the conditions imposed by the Supreme Court?
Nabanggit din ho yun.
During the press conference?
Kung hindi po ako nagkakamali, parang binasa po yun. Binasa po yun ni Midas Marquez.
Pero ayon din sa inyong pag-testify dito, unan yung natanggap yung kopya ninyo around 8:16 a.m. the following day, November 16.
Opo, 8:25.
Kailan nyo po unang nalaman na merong irregularities, merong hindi pagsunod do sa mga conditions na na-impose?
Nung natanggap ko na yung yung November 18 resolution po.
November 18
Opo,
resolution.
Na natanggap, kung hindi po ako nagkakamali, on the same day, November 18.
Kailan nyo po pinagbawalan si Ginang Arroyo na umalis ng bansa papuntang kung saan man, lupalop yun?
Yung attempt niya po nung
In other words, noong hindi nyo siya pinayagan na umalis, hindi nyo pa alam na may mga kondisyones na hindi na-fulfill doon sa TRO.
Hindi ko pa po alam kung talagang na-fulfill na yung mga conditions as of that time. Kasi ang alam ko po, Your Honor, is that pag meron pong mga kondisyon ng isang order, kailangan meron hong confirmatory order yung korte na ito nga itong mga kondisyon na nakasaad dito ay na-comply na ng party concerned.
Pero hindi nyo alam na merong kondisyon, yung condition number 2, requirement number 2, yung pag-a-assign ng legal representative, hindi pala na-comply dahil mali yung isinumite ng kanyang lawyer, si Ferdinand Topacio, di ba?
Opo, nung gabi pong yun, kung ano sa mga kondisyon na yon ang na-fulfill na maski nga po yung bond, hindi ko pa rin ho yun alam kung naibigay na yon nung araw na yon.
So that prompted you to order the immigration officers at the airport, including the personnel of the NAIA authority, to not to allow her to leave the country that evening.
Opo.
Ano po ba ang diferensya ng WLO at saka ng HDO?
Ang order ay pinagbabawalan na umalis ang isang either nasasakdal or respondent in a preliminary investigation case. At ito ay may duration ng 5 taon, 5 years, unless lifted or revoked. Yung WLO naman po, watch list order, ay essentially, ang effect ay hindi basta-basta makakaalis unless makakuha rin po ng lifting order o allow departure order, pero ito po ay only for a period of 60 days and not 5 years.
An HDO is issued by the court, by the regional trial court. Kapag na-file ng information, whether or not na-issue ng warrant, ay may kapangyarihan sa ilalim ng batas na mag-issue ng hold departure order.
Opo, ang korte po ay may kapangyarihan at yung Department of Justice din po, under Department Circular Number 41, ay meron din po kapangyarihan.
Kapangyarihan.
Opo.
Sino po ang nagbigay ng kapangyarihan sa DOJ na mag-issue ng watchlist order?
Nasa 41 ay ito po ang basehan po nito kasi ang Circular Number 41 po ay kagaya ng sinabi ko po kahapon, ang nagpalabas po niyan ay yung dating Secretary of Justice Alberto Agra at yung mga dati rin po mga circulars before Circular Number 41 ay meron din po doon tungkol sa HDO. So yung mga dating circulars, in-issue rin po ng mga dating Secretary of Justice. Ang batayan po ay yung sa Administrative Code na kung
292.
saan... Opo,
EO 292.
Executive Order 292.
Natin yung pinagkopyahan, yung sinite dito, which is yung Circular Number 18. Hindi po ba? Yun yata pinanggalingan nito eh.
Opo.
Department Circular Number 18. At ang sinasabi doon, binibigyan ng, wala yung notes ko, binibigyan ng kapangyarihan ng Secretary of Justice para utusan ang immigration. Pero pagka sinabi pong immigration, yun po'y patungkol lamang sa naturalization, mga naturalized at sa mga aliens. Hindi po ba?
Basically, opo.
Opo. So, ang sinabi niyo po kahapon sa mga pagtatanong ng aking kaprobinsya na si Senator Bong Revilla, mayroong effects of a law ang Circular Number 41.
Opo, has the force and effect of law.
Yes,
being an
but it is not
administrative
a law.
issue. It's not strictly a law.
Is there a law that authorizes Circular Number 41?
Yung batas
Mr. President, marami po akong pagtatanong na 30 segundo lang.
You can go on anyway.
Thank you po.
Wala pong batas authorizing yung Department of Justice o yung Secretary of Justice na mag-issue ng hold departure order or watch list order. Pero ang batayan po dyan ng poder na yan ay yung aming mandato under the Administrative Code at ito po under the rulemaking powers din po ng department for the effective implementation of its mandate at saka po yung exercise ng police power.
Now, may an agency, in this case the DOJ, grant to itself by issuing a circular that power? Kayo mismo, hindi po ba self-serving yun? Pagka kayo mismo ang nag-grant ng power sa sarili ninyo sa pamamagitan ng isang circular, hindi po ba ang nararapat lamang, it is basic for that agency, in this case, again, the DOJ, to seek the support of Congress by way of an enactment. Hindi po ba?
Yan ho ang idea. Meron po sana pong talagang batas na talagang directly, expressly, categorically granting us that power. Mas maganda po sana yon. Pero all these years nga po, wala pa. Hindi pa ho yan binibigay o hindi pa ho yan na pinapalabas ng Kongreso. Pero meron po kaming batayan, yung sinasabi ko po kanina sa Administrative Code, meron po kaming kapangyarihan na mag-issue ng mga rules and regulations na sa tingin namin ay makakatulong para talaga magawa po namin ng maayos ang aming mandato, which is to administer the criminal justice system, investigate crimes, and prosecute criminal offenders.
Have you even attempted to ask Congress to enact a law para mabigyan kayo ng ganong kapangyarihan sa ilalim ng ating batas?
Meron pong mga ginagawa ngayon na mga bills o mga draft ng mga i-submit po namin na proposal sa Kongreso. At alam ko po na meron din mga pending bills tungkol dyan, pero hindi ko po alam kung ano na pong pinaka-status, kung nakumpleto na po yung bill.
But in the meantime, that there is no law, you cannot implement or you cannot implement Circular 41. Hindi po ba? Kasi hindi po kayo pwede mag-grant ng power sa inyong sarili at pagkatapos kayo rin na magpapa-implement. Parang wala po sa ating saligang batas yun.
Recognize po yan na kung meron po kaming rule-making power aming paggawa ng aming mandato ay pwede po, and the police power. Kasi yung police power nga po ay nasa Kongreso nga po yan, but it can be delegated. And it can be delegated through the power of the agency concerned to issue rules or to promulgate rules and regulations para mapadali ang trabaho. At yung pagbibigay o pag-i-issue po ng HDOs and WLOs ay long recognized institutional practice na po yan ng DOJ. Mulat sa pulpa po ay yung mga dati pong mga secretaries of justice, kasama na rin po yung lahat ng mga secretaries of justice na mga inappoint ng dating Pangulo. They have been issuing whole departure orders and watch list orders bago pa man po yung circular number 41.
Alam ko po yun dahil ginamit po ito ni dating Pangulong Arroyo to go against her perceived political enemies. Hindi po ba? Kasi minsan naabutan ko si Congressman sa Campo, kawawa, nandun sa isang kwarto doon sa immigration, at ang dahilan lamang kung bakit hindi siya paalisin ay merong watchlist order. Sa akin pagkaintindi, as the name connotes, or as the nomenclature indicates, watch list, parang ang connotation lamang, bantayan nyo yan, alamin nyo kung saan pupunta, alamin nyo kung kailan babalik, and nothing more. Hindi naman pwedeng pag-watch list, sasamaan na ng hold. Kaya nga meron tayong tinatawag na hold departure order, at meron tayong tinatawag na watch list order, kasi magkaiba po yung dalawa. Kanina, tinanong ko sa inyo, anong diferensya? Sa inyong paliwanag, wala ako nakita ng diferensya. The difference is the same.
It's just the period. Yung epekto po ay
Hindi lang
parang...
Pati yung epekto po, dahil hino-hold yung Pilipino para hindi makalis ng bansa by virtue of a watchlist order.
Kanina na watchlist order, pero yung epekto po ay halos pareho in the sense na hindi ho basta-basta makakaalis, na hindi muna magpaalam sa Department of Justice sa pamamagitan ng pagkuha ng lifting order o ng allowed departure order. And ang epekto nga po, ang duration nga po is 60 days instead of the longer period kapag HDO na 5 years. Doon po sa sinasabi nyo yung ginagamit po ng dating Pangulo against perceived enemies, well, maaaring naabuso nga po yung poder na yan.
At ngayon naman po, ginagamit naman natin doon sa ating perceived political enemy rin. The same circular.
Sa akin po, you don't have to worry about that, sir.
Pero nangyari po
I don't use my powers for any improper motives, especially for any I should say political vendetta. I don't do that.
Hindi po ba maliwanag sa ating saligang batas, Article 3, Section 6, na yung right to travel dapat ating i-uphold? Maliwanag po yun dahil hindi ko na po kailangan basahin yung provision dahil alam nyo naman po yun.
Opo, meron po talagang right to travel.
May mga exception lang.
Just like any other rights, meron po mga exceptions. It's not unlimited.
Yeah, national security, public health, and public safety.
Opo.
Saan po pumasok sige ng Arroyo doon sa tatlo na exception?
Yung sa tatlo po, strictly speaking, hindi ho natin pwedeng tugma yon. But ang argument po namin dun sa kaso namin ngayon sa Supreme Court is that hindi po, it is not meant to be an exclusive enumeration of those exceptions kasi meron nga pong mga recognized exceptions ngayon. The fact that the court itself, the regular courts, can issue HDOs in cases pending before them kahit wala dun sa tatlong stated exceptions,
yung sa korte po,
ay pwede.
Kasi ang sinabi ng Constitution, as may be provided by law.
Opo.
Ito po bang Circular 41, meron po bang batas tulad ng tanong ko kanina, is there a law authorizing it?
Wala po. Wala po. Pero yung meron nga ho tayong mga jurisprudence, katulad po nung tungkol dun sa power ng PCGG, ay isang kaso po, Cantwong case, ay hindi nila pinakialaman yung power of the PCGG to issue whole departure order kahit wala po yan sa batas ng PCGG. At yung batas po ng PCGG is Executive Order number 1. Pero meron pong ilang kaso, yung isa nga po ay nakarating sa Supreme Court na inaffirm po nila yon yung power of the PCGG to issue HDO kahit wala pong batas na nagsasabi tungkol doon. Another example po, yung mga travel ban po. In another case, Pasay versus then Secretary Drilon. In-affirm po yon yung the authority to impose travel ban. Now, travel ban po, that is tantamount to restraining the right to travel. May ilan-ilan pa pong mga example.
Nabanggit niyo po yung EO 292. Ito po yung sinasabing provision. Ano? Babasahin ko po para maliwanag, para lang maiparating ko sa inyo na hindi niyo pwedeng gawin basehan yon. Ito. Ang pinagbasihan dito, yung Circular number 18, which in part cited Section 3, Paragraph 1, sa Paragraph 2 and 6, Chapter 1, Title 3, Book 4, EO 292. Yun ang source ng authority ng Department Circular number 41. Tama po ba?
Opo, I don't
Ang sinasabi po ng Section 3, Paragraph 6, it authorizes the DOJ to provide immigration and naturalization services and implement the laws governing citizenship and the admission of stay of aliens. Hindi naman po aliens sige ng Arroyo.
Meron pa hong mga ibang basehan, yung Circular number 41.
For my education, pwede niyo po bang banggitin? Ang kinukot ko po rito si Father Bernas eh. Baka nakalimutan niyang isulat yung sinasabi niyong ibang...
Meron pa hong mga ibang basehan yung Circular number 41, yung mga provision po tungkol dun sa sa mandato, sa mga powers and functions ng DOJ. Lalo na po yung tungkol nga po dun sa the DOJ administers the criminal justice system in accordance with the accepted processes, investigate crimes and prosecute criminal offenders, etc. Now, because of that mandate, meron din po kami under the EO, under Administrative Code, in another provision of the Administrative Code, the rule-making powers. So doon po namin pinasok, o doon pinasok nung mga nag-draft nung Circular number 41, the power to issue rules and regulations. Ito nga po, Circular number 41, the power to issue HDO and WLO for the effective discharge of the mandate of the powers and functions of the DOJ under the Administrative Code.
Rule-making power of the DOJ. Tama po yun. Pero dapat po may pinagbabasihang batas yun. Kung hindi man salig ang batas, batas na ipinasa ng Kongreso. Sa ngayon po, ayon sa inyong pagsang-ayon kanina, wala naman po lumalabas pang batas na ianak ang Kongreso, bakit naglabas na kayo ng Department Circular number 41? Hindi ko po sinasabing hindi ako sumasang-ayon sa inyo na napigilan si Mrs. Arroyo. Maliwanag po yun. Sumasang-ayon po ako sa inyo, pero hindi ako sumasang-ayon sa legalidad ng inyong ginawa.
Yung Circular number 41 po, gusto ko pong ulitin na hindi ko pagdating ko po sa Department of Justice, nandyan na po yan. And yung mga HDOs and WLOs, and sa tingin ko po, it enjoys the presumption of constitutionality and validity. So until otherwise declared, as until declared by the Supreme Court as unconstitutional or invalid, we should assume that Circular Number 41 is a valid exercise of rulemaking powers of the DOJ and also exercise of police through the executive department.
You cited national interest. Correct me if I'm wrong, pero yun ang narinig ko sa interview ninyo, na you cited national interest as your justification para pigilan si Mrs. Arroyo at implement.
Isa po yan sa
sa Constitution yung national interest kasi tatlo lang pong nakalahad dun eh. Kung gusto natin i-expand na isama yung national pag-usapan natin sa Kongreso, lower house and upper house para ma-expand kung gusto nitong basta't wala lang hindi lang contrary sa provision gawing isang justification. But in the meantime, that it is limited to 3 na public safety, public health, at saka national security, wala po tayong magagawa kung hindi sundin yung Article 3, Section 6 ng Constitution at sundin yung mga umiiral na batas tungkol dito.
Meron po tayong Circular Number 40.
Ginang Secretary. Nagkasundo na po ang batas authorizing Circular Number 41.
Administrative issuance po yan, kahit hindi po siya batas, but it also enjoys the presumption of constitutionality and validity dahil sa tingin po namin ay sakop po yan talaga kapangyarihan ng DOJ under EO number 292. And it's actually in the exercise of police power. Now, yung delegated authority ng gobyerno na ipagpatupad ang isang batas provided na may mga reasonable standards na mga nakalagay po dyan sa batas at dun din po sa administrative issuance. Ang position po namin, yun po ang position namin, official position na pinaglalaban po namin sa Supreme Court dito po sa dito sa consolidated cases.
Sa pag-implement noong hindi nyo pagsunod sa TRO. So, noong November 15, maliwanag na hindi nyo pa alam yung mga kondisyones na na-violate or one of the conditions that was not just the same, pina-implement nyo yung or sinuway nyo yung TRO. So, can you now confirm that you defied the TRO issued by the Supreme Court?
Whether I'm not.
Okay, you did not follow.
Yes,
you did not abide. You did not abide by the TRO.
Yes, sir. Yes, Your
Honor. Po tayo doon.
Hindi po namin sinunod. Nga po nung oras na yon, yung gabi po na magtangkang umalis yung dating Pangulo, wala pa ho kaming official copy ng TRO. At pangalawa po, since alam ko po, nung in-announce nga po ni Maidas Marquez na may mga kondisyon, hindi ko pa rin po alam, hindi pa rin po namin alam kung natupad na po yung mga conditions na yon.
Maraming salamat po. Thank you, Mr.
Salamat
President.
din po.
Thank you. Majority Floor Leader.
Has withdrawn, Mr. President. Senator Drilon wishes to be recognized.
The
And then
gentleman
Senator
from Iloilo, Senator
Legarda
Drilon.
Estrada.
Yes. Madam Witness, correct me if my recollection is wrong, but I seem to recall that in yesterday's hearing, in response to a question on why you are holding the Chief Justice responsible on what appears to be a collegial decision, you substantially answered that the Chief Justice has some ascendancy over the Justice. Is my recollection correct?
In so many words, yes po.
Yeah, because I have not reviewed the transcript. But is my recollection correct of your answer?
Opo.
Can you elaborate on what exactly do you mean by this? Because really, on the assertion that you cannot blame the Chief Justice on a collegial decision. Can you elaborate on this?
Salamat po, Your Honor. Yun nga po yung sinasabi medyo mahaba-haba nga akong kwento. Although I did not exactly mention the word no, because the word ascendancy or something, but I was saying that sa pagdidesisyon po, isang boto nga lang po ang Chief Justice. Sa pagdidesisyon. Pero meron pong mga bagay-bagay, meron pong mga sa workings ng Korte Suprema na since si Chief Justice po, siya ay primus inter pares at siya rin yung pwede nating matawag na Chief Executive or Administrative Officer ng Korte, siya lamang ang pwedeng mag-utos. Binasa ko po yung internal rules ng Supreme Court at ilan po sa mga bagay na siya lang ang pwedeng gumawa ay yung katulad po nung pagpapalagay, yung directing the immediate inclusion of any matter in the agenda. So kung meron ho siyang gustong ipa-special raffle, siya po ang pwedeng magpagawa niyan. Meron po siyang gustong matter na iti-take up, ipapasingit sa agenda, siya po yan. Siya rin po, sabi po ng internal rules, siya rin po ang nagbibigay sa clerk of court nung kanyang mga notes on the actions taken by the court. Siya yung nag-take down ng notes. At yung copy ng agenda na naglalaman ng kanyang handwritten notes, yung handwritten notes ng Chief Justice, yan ang magsisilbi as basehan dun sa preparasyon ng minutes. Binabasa ko po yung relevant portions ng internal rules, tinatagalog ko lang po. Yan po ang magiging basehan ng preparasyon ng minutes ng proceedings. Siya rin po ang nag-approve ng draft minutes at siya ang nagbibigay ng final approval dun sa paglalabas ng mga resolusyon. Kasama na dyan yung mga minute resolutions and extended unsigned resolutions. Now, kailangan nung kasi matandaan natin yung mga function na yan o kapangyarihan na yan ng Chief Justice sa mga internal workings ng Supreme Court. Dahil nga po, dun sa mga nalaman natin na mga irregularidad na binunyag ni Justice Sereno. Kasi nga po, kung ang Chief Justice ang siya lamang ang mag-approve finally ng pagpalabas ng isang resolution, siya yung nakakaalam kung tama o hindi yung ilalabas na resolution. Lalo na po, na based din po sa internal rules, at sinabi po yan din sa, kung di ako nagkakamali, sa parehong dissenting opinions ni Justice Sereno and Justice Carpio, ay yung mga unsigned extended resolutions tsaka minute resolutions, hindi na to pinapaikot sa kanila, sa other members of the court, bago ito pinapalabas. Klarado po yan. Now, yung TRO, November 15, klarado po na subject to conditions. At sabi po sa dissenting opinion ni Justice Carpio, may isang portion, yung November 15 TRO, dun sa number 1 condition, isang portion po dun, I'm just looking for, Your Honor, for the PRO. Ito pong number 1 condition. The petitioners shall post a cash bond of 2 million pesos payable to this court within 5 days from notice hereof. Failure to post the bond within the aforesaid period will result in the automatic lifting of the temporary restraining order. Yung pangalawang sentence ho, sabi ni Justice Carpio sa kanyang dissenting opinion noong December 13, wala daw po yan. Yung failure to post the bond within the aforesaid period will result in the automatic lifting of the temporary restraining order. Hindi daw po yan diniscuss. Pero bakit ho nandito sa November 15 TRO? Number 2, Yung November 18 naman po, November 18, it was a Friday. Since hindi nga po nakalusot yung TRO, in the sense na hindi po namin sinunod, dahil nga yung mga kondisyon, hindi pa klarado kung na-comply na. So nagpatawag po ng special session. Now, yung sa special session, meron mga ilang bagay na pinag-usapan at pinagbotohan ng Supreme Court. Sabi uli, doon sa dissenting opinion ni Justice Sereno, tsaka sa sulat ni Justice Carpio sa punong maestrado noong November 24. Now, sabi po, yung November 18 po, pinagbotohan yung nagkaroon ba ng compliance doon sa mga conditions. That's number one. That's one of the matters. Isa pa po, at yung naging resulta ho pala doon yung sa question na yon, meron bang compliance? Sabi po ng korte, by a vote of 7-6, walang compliance. So dahil walang compliance, ano ho ba ang ibig sabihin nun? So that's another issue na pinagbotohan nila. Suspended ba yung TRO? Yung effectivity ng TRO dahil nga walang compliance? Ang sabi nila Justice Sereno and Justice Carpio, ang malinaw na naging resulta ng botohan doon by a vote of 7-6 is that hindi na lang nila hindi na lang nila sasabihin yun na suspended siya dahil dahil yun naman talaga ang ibig sabihin ng isang conditional TRO. But meron mo kasing isang justice na sinabi, common sense naman yan, understood na yan by any lawyer. Kaya dapat hindi na lang natin yan categorically sabihin. Parang it's a vote of silence na lang. The 7-6. Now, kaya lang po, so dahil nga po, kaya lang po, yung November 18 resolution na pinalabas nung araw din pong yun, wala po nakalagay doon yung 2 punto na yan. Yung pinag-usapan nila at pinagbotohan na number 1, hindi pa natupad yung mga conditions. Number 2, deemed suspended yan, pero nothing there. Ang nakalagay lang po sa November 18 is pinapa-submit uli yung mga petitioners through their lawyers yung compliance na tumutupad dun sa condition number 2. Ang sabi ko po kanina, under the internal rules, ang reso po, hindi yan basta-basta makakalabas kung hindi muna dumaan o i-approve ng Chief Justice. Napansin po yung depekto na yan dun sa November 18 resolution ni Justice Carpio, according to him and according to Justice Sereno. Kaya sumulat po siya o request po niya na pag-usapan yun noong November 22 at i-clarify yung naging botohan noong November 18. Inassign po ni Chief Justice yung pagsulat o pag-prepare ng clarificatory resolution kay Justice Velasco in consultation or in coordination with Justice Carpio. So the next day, dinala o binigay kay Justice Carpio yung draft resolution, clarificatory resolution from Justice Velasco. Nagkasundo sila sa number 1 na tama ngayon na hindi pa nakapag-comply dun sa mga conditions. Pero yung number 2, medyo hindi sila nag-agree. Sabi ni Justice Velasco daw po, hindi ko masyadong nakuha yung nuance o yung naging agreement natin na wag na nating sabihin diretso. Kasi understood naman, common sense naman. Sabi ni Justice Carpio, he was insisting daw na hindi. Very clear yung naging usapan po natin na kasi common sense, kaya pwedeng hindi na sabihin. Ang problema po, nagpadala si Chief Justice ng kanyang version ng clarificatory resolution of November 22. Yung kinaklarify nga po nila yung November 18. At napansin ni Justice Carpio, mas mali yung nakasaad doon, yung version na galing kay Chief Justice. Kasi po, ang nakasabi na ngayon dun sa version na galing kay Chief Justice ay there was substantial compliance with the conditions. And number 2, the TRO was not deemed suspended. So, dalawa na po yung mali. So, ito ay galing kay Chief Justice. Kung hindi po napigilan ni Justice Carpio, kasi request nga niya po na pag-usapan uli, kasi mali, siguro lumabas yon nung November 22. Kaya po, nung after November 22, kaya kailangan ho nilang magbotohan uli nung November 29. So, November 29, ganun pa rin yung botohan, 7-6 in favor of no compliance. Doon sa unang tanong, sa pangalawang tanong, medyo nabaliktad na po, instead of 7-6 na deemed suspended, but let's just keep silent, naging not suspended dahil meron pong isang miyembro na bumaliktad. So, ibig pong sabihin, dahil ang chief, siya po ang talagang may karapatan o may poder na nagpapalabas ng ganyang mga resolution, may mga maliho na pinapalabas. Now, isa pa ho doon, yung spokesperson na sabi ni Justice Sereno is clothed with the apparent authority by the Chief Justice to be announcing these things, mali rin po ang mga in-announce. Katulad nung immediately, pwede na, executory na daw po, and noong November 15, pwede na makaalis yung dating Pangulo. Noong November 18 naman, klarado dun sa botohan noong November 18 na hindi pa deemed suspended yon, pina-announce din po yon. Kasi noong November 18, kung natatandaan nyo po, aalis na naman dapat po yung dating Pangulo. So yung mga ganun pong, sa tingin ko po, maneuvering of the internal actions of the Supreme Court para lang mapaboran ang isang party ng kaso.
Well, thank you very much. I did not expect that my simple question would merit a very long explanation.
Pasensya na po, para po maintindihan.
I have no more questions.
Thank you very much,
Mr. President.
Yes,
I would like to
gentleman from Ilocos Norte.
I just like to make an inquiry to the chair. The witness has just testified in the narrative on events that happened within the Supreme Court. Therefore, does the character of that narrative that we just heard from the witness fall into the category of hearsay in like fashion as what we had heard previously?
We are all intelligent members of the Supreme Court. I think we will know how to appreciate the testimony of the...
May I just...
I understand your answer, Mr. President. Thank you very much.
Your
And
Honor,
we will
may...
exercise
let the witness answer.
May I just add something po? Yes, primarily or predominantly or by and large, my testimony on those matters, internal matters, is indeed hearsay.
Thank you.
Because I was never present.
Yeah.
But let's also take note of the fact, okay, these decisions or these resolutions or dissenting opinions are a matter of judicial notice, and there are aspects of the accounts of Justice Sereno which I can say I have personal knowledge. For example, when she stated...
Madam Witness, thank you very much. I think you have covered those points in the narrative that you made, and again, by your own categorization, they are hearsay. So I just wanted to know how to handle that narrative that we just heard.
Your Honor,
thank you, Madam Witness. Thank you, Mr. President.
Let us allow the witness to
thank you, Your Honor.
finish their statement.
As I was saying there are aspects of the account of Justice Sereno which I can claim personal knowledge. For example, when Justice Sereno said that the spokesperson, Midas Marquez, misrepresented of the voting on those issues that I mentioned, especially the issue of whether the TRO is deemed suspended. The announcement of the spokesperson was it was 9-4 instead of 7-6, and that and other disclosures. So in a sense, I have personal knowledge. Also, when she said that she has a December 2 dissenting opinion, but was suppressed or was not allowed to be promulgated or released, the Secretary of Justice, as a party respondent, indeed did not receive any such resolution of December, any such dissenting opinion of December 2. Kasi pinigilan nga daw po. So, in a sense, I have personal knowledge about that.
We take note of the statement of the witness that sabi niya, pinigilan nga daw po. So, nandyan yan. Okay.
Okay. Well, those points are well taken, Madam Witness. And again, as the President has advised all the senator judges, we will apply our intelligence in discerning what is the wheat and what is the chaff in this narrative. Thank you, Mr. President.
Mr. President, may we recognize Senator Gregorio Honasan.
The gentleman from Sorsogon, Senator Honasan.
Thank you, Mr. President. Madam Secretary, magandang hapon po.
Magandang hapon po.
Madam Secretary, hindi na po sana ako magtatanong. Kaya lang, bihira ho kami magkaroon ng testigo na kalihim. Kaya lahat po ito ay paglilinaw lamang. At sana po, pagbigyan niyo kami, no? Kanina po, gusto ko lang sanang susugin yung mga issue na ni-raise ni Senator, kagalang-galang Senator Lacson. Itatanong ko lang kung hindi batas ang naging basehan ng pagpipigil, ng pag-alis, ng balak akusahan, at sabi nga ninyo itong Department Circular number 41, Madam Secretary, ito po ba ay na-publish para alam ng mga apektadong ahensya? Opo.
Opo, Circular number 41.
Na-publish po ito?
Opo.
Opo, salamat po. Pangalawa po, kung ito ang ginamit, kung itong Circular number 1 ang ginamit para pigilin yung pag-alis ng magiging akusado sa pamamagitan ng watch list order na nagpigil sa paglisan, kailangan po bang probable cause para i-apply ito?
Hindi po under Circular number 41 kasi...
Opo, dahil hindi nga ho nakasama sa Section 2 no, ng Circular 41.
Not necessarily. Dahil nga po, one of the instances na pwede po kami mag-issue ng HD or WLO is kapag ang isang respondent ay undergoing preliminary investigation. So kung hindi pa po tapos ang preliminary investigation, wala pa pong determination of probable cause.
Opo, I'll take your word for it.
Opo.
Okay. Madam Secretary, kung ho ito, no, alam nyo naman, hindi tayo abogado. Alam naman ninyo kung saan tayo nanggaling. No? Kapag nag-order ang Korte Suprema at ibig nitong masunod yung order niya at hindi sinunod, ano ang gagawin ng isang Korte Suprema? Saan siya tatakbo? Saan siya dudulog?
meron ng mga inherent and implied powers or even express powers ng Senate, ang Korte Suprema na pwede nga pong ipa-contempt ang isang litigant na hindi sumusunod sa kautusan ng Korte.
Pero yun po, I'm not trying to beat the issue to death, no? Pero medyo protracted ho yun, no? Matagal, bago mapatupad dahil maraming proseso na dadaanan. Is that an accurate?
Opo, dahil, kasi nga po siyempre ipapa-explain muna yung litigant concerned na hindi sumunod. So may due process din po.
In short, sa madaling salita po, medyo matagal.
Depende po yan sa action.
Okay. Compared to, pag kayo po ang nag-utos at saka ibig niyong ipatupad, obviously, hindi ho nakaalis yung akusado, no? So in other words, yung option sa inyo bilang kalihim ng Department of Justice, mas mabilis na susunod kisa sa dun sa utos ng Korte Suprema. From a layman's point of view po, pwede hong ipaliwanag ninyo kung paano ko ito iintindihin o unawain.
Opo, tama po kayo, yung punto nyo po, kasi syempre pag nagbibigay din ng mga kautusan ng ang Secretary of Justice, katulad nga po ng HDO or WLO, ay yan ay pinapaalam kaagad sa Bureau of Immigration. And then so kung ano pa kung mga pwede na gawin ay yung Secretary of Justice having control and supervision over not only the Department of Justice proper but also the attached agencies. And therefore, pwede hong natutupad kaagad yung pinag-uutos ng Secretary of Justice.
Opo. Anyway po, ang na-invoke natin doon is national interest, which is very clear naman.
Opo.
Yan po, Madam Secretary, I'll go to what I really want to ask you. No? Alam niyo po, talagang sinamantala ko ang pagkakataon na ito dahil dati po kayo ang chairman ng Commission on Human Rights.
Opo.
Okay. Actually, Secretary, pareho ho yung pinanggalingan natin. Kaya lang ako ho dun sa kabila, no? I was on the receiving end. At kailangan po, wag natin ito makalimutan dahil it will be tragic if we forget. Tulad po, in your case, as chairman of the Commission on Human Rights, sa inyo ho tumatakbo yung mga biktima ng extrajudicial killings, yung mga involuntary disappearances. Hanggang ngayon ho, dala ninyo yan sa inyong pag-iisip at puso. Yung karanasan ninyo bilang chairman ng Commission on Human Rights dun sa mga tumatakbo, yung walang matakbuhan.
Opo, I remain to be a human rights advocate and defender.
Opo, hindi ho nawawala sa pagkatao niya.
Opo.
Ako naman po iba. Alam niyo po, pag nag-imbento ng intelligence report, there is no, this is just my opinion, no? There is no known legal defense against a fabricated or inaccurate intelligence report. Lalo na kung i-invoke yung national security. Kulong ka muna bago ka bigyan ng pagkakataon magpaliwanag kung bibigyan ka ng pagkakataon magpaliwanag. Ganun po ang karanasan ko. Yun nga ho, kinausap ko lang sina Senator Trillanes with my National Recovery Program. Minasama na yun. No. But that's behind us now. Dito po sa Constitution, wala naman ho akong ibang mabasa dahil nahihirapan ho ako magbasa at saka umunawa, no? Yung Article 1, after the preamble, nakalagay National Territory, Article 2, Declaration of Principles and State Policies, Article 3, Bill of Rights, kaagad. Dito ho, impact ho yung isang prinsipyo na itinanong ko sa prosecution at sa defense. Sabi ko, dito ba sa trial na ito, kahit na sui generis ito, political process, tayo ba ay magkakasundo na isa sa mga prinsipyo na hindi natin dapat bitiwan, yung presumption of innocence? Pumayag naman sila. Totoo daw. Kayo po?
Yes, there's always a constitutional presumption of
na ho yan.
innocence.
Dahil ito po, Section 14, Mr. President,
Let the Senator continue.
Okay. yung pungkwan, presumption of innocence, section 14. Pero yung probable cause ay section 2. In other words, sa priority, ayon sa aking pagkaunawa, dito ho lahat umiikot, no? Ngayon po, itatanong ko lamang, no? Madam Secretary, malinaw naman sa inyo na itong kaganapan ngayon, itong prosesong ito, ang nag-uudyok dito, hindi paghihiganti.
Opo.
Okay. Hustisya.
Opo.
Rule of law. Dahil kung ang nag-uudyok dito ay paghihiganti, ang rule natin is no rules.
Definitely.
Free for all. You can
Opo.
say or do anything you want. Sa paghahanap natin ng katotohanan at hustisya, hindi ko pwedeng either or ito, no? Gusto nating parusahan yung mga nagkasala nung nakaraan. Pero gusto rin natin na wag na itong maulit. Yung po ba itama?
Opo.
Hindi ho ito either or, no?
Yes, sir. Yes, Your Honor.
Alin ho rito ang mas matimbang? Dahil political process nga ito, at, hindi lang political process, kundi sui generis pa.
Ang palagi mo matimbang sa aking perspektiba bilang Secretary of Justice ay yung mga prinsipyo ng truth, justice, and accountability. Yan po palagi.
Ano ho ang pinagkaiba sa inyong pananaw ng paghigante at hustisya? Hindi ho yung technical definition. Kaya ho ba natin sa korteng ito mahimay, mabasa yung nasa puso at pag-iisip nung nasasakdal, nung prosecution and defense, kung nasusunod pa ang linyang ito that distinguishes between revenge, paghigante, at hustisya?
Siguro po naman,
Madam Secretary, alam niyo po kasi, ang hirap-hirap para sa ating lahat, lalo na yung senator judges, na pagdaanan ng prosesong ito. Di ba? Kayo ho, hindi ho ba kayo nabibigatan?
Talaga naman ho,
ang hirap po, no?
Napaka-importante nitong proseso na ito. This is historical. Ngayon lang po tayo nagkaroon ng ganitong proceedings involving Chief Justice. At kaya nga po, nandyan ang proseso, nandyan ang konstitusyon, at nandyan po kayo as senator judges, and ang mga facts po ay naibibigay sa inyo, and nandyan po yung articles of impeachment, kung ano po ang mga nakukuha natin na mga ebidensya ngayon o mga pananaw natin, yun po ang magiging basihan. And of course, yun nga ho, pag-uusapan nyo pa kung ano ang magiging quantum of evidence, although nalinaw na po yan ng presiding officer na hindi ho ito pwedeng proof beyond reasonable doubt dahil hindi nga po ito criminal case. Dapat po mas bababa ang batayan. Now, so, talaga hong mabigat itong proseso na to. Very critical.
Opo. Kaya ko sinabi, kaya ko tinanong kung nabibigatan din kayo. Dahil okay lang po kung procedurally we divide the House. Majority rules. No? Ang problema ho, para bang we are dividing the country already. That's what...
Hindi po.
Well, that's good that you feel that way, no? Dahil in order to avoid any perception that the ultimate objective of this trial is other than the rendition of justice, kahit na liberal ang pag-apply ng rules, wag lang natin galawin o pakialaman yung ultimate rule, which is the Constitution. Do you agree?
Opo.
Okay. Dito po, sa parting ito, ibig ko lang i-inject yung sinabi ni former President Ronald Reagan. No? Of course, sabihin natin Amerikano yun, wala naman siyang kinalaman dito, pero he is considered the great communicator. In fact, is the only president I know, former president, for whom an aircraft carrier was named while he was still alive. So, kailangan kahit papano, tingnan natin kung may mapupulot tayong aral. Sabi niya ho ito, no? Protecting the rights of even the least among us is basically the only excuse the government has for even existing. isang karapatan ng isang pinakamaliit sa atin. Yun lang ang buong dahilan para manatili ang pamahalaan. Would you more or less agree to this?
I would generally subscribe to that.
Okay.
Every citizen has rights. Lahat po tayo may karapatan. Individual na mga karapatan. Ang Estado po, meron din mga karapatan. Okay. So may mga usapin po na kailangan po nga natin binabalanse. Yung mga individual rights or individual interests as against the higher interests of the state. Minsan po, o kadalasan, hindi po madaling sagutin hindi mo madali ang pagbabalanse.
Opo. But, as a constitutional principle, when you invoke the balancing of interest, kayo na rin ang nagsabi kahapon. Pag in-invoke yung the right to life, tabi lahat. Tama ho ba yan?
That's the highest form of right under the Bill of Rights and under the Universal Declaration of Human Rights.
Tama ho yan. So, you agree?
Opo.
Okay. Kaya naman, sa Section 1 ng Article 2, no person shall be deprived of life, liberty, or property. If you notice po, Madam Secretary, the sequence, no? No person shall be deprived of life.
Opo.
Second, liberty, property. May itatanong lang po ako. Tinanong ko na rin ito, presumption of innocence. What about presumption of honor? Yung bang may akusado, pero bakit naman pati yung mga anak at apo tinatamaan na rin? Yung ba'y katanggap-tanggap sa atin o sa iyo po bilang Secretary of Justice? Okay lang ba yan o paano po? I mentioned this because I think once upon a time, you and I have been exposed to this. No? You have been exposed to this. Pag dumulog sa iyo yung walang kalaban-laban, di ba? Hindi mahanap yung anak. Hindi mahanap yung family member. Hindi ba live ang pinag-uusapan dito? So, gusto ko lang sariwain yung alaala natin para hindi natin ito makalimutan, no? So, ano po ba ang pananaw ninyo rito? Dapat po bang idawit dito sa pagnanasa natin na mahanap yung katotohanan at hustisya?
Well, meron nga hong presumption of innocence at kaya nga po dumadaan tayo sa ganitong proseso. Kaya nga po yung prosecution ay nag-present ng ebidensya. So yung presumption of honor naman po, dignity, dignity and honor is also within within every person. But when you lose that honor, honor is...
Mr. President, Madam Secretary, in a previous lifetime, I think in your profession also, no? Honor is more precious than life. And recent history has taught us that people sometimes take their own lives when their honor is jeopardized. And the future of their children and grandchildren are put in jeopardy. You agree?
100%, Your Honor.
Okay.
Honor really is
Apo.
more important than life.
Last question, Madam Secretary. So, let's just put this on record. Sa tingin ho nyo so far, prosecution pa lamang po ang nagpipresenta, ito hong prinsipyo ng probable cause ay nasusunod naman. Ibig kong sabihin hindi natin binaliktad. Hindi ko pinupuna ang prosecution dito. Hindi pa naman nagpipresenta yung defense. No? Ibig sabihin, sa kaloob-looban ng puso natin, applying all our standards, ultimately leading to an application of a judgment call which we call calibrating our moral compass or conscience. Naniniwala tayo na may probability nga ho probable cause, no? Malamang may krimen na naganap. Hindi natin yung halugugin muna natin lahat, baka sakaling may matagpuan tayo na probable cause o ebidensya. Hindi mo natin binaliktad ito. So I'm asking you, Madam Secretary, Secretary of Justice, former chairman of the Commission on Human Rights, na so far sa proseso, sa inyong obserbasyon, sa pagdalo ninyo rito bilang testigo, nasusunod pa itong nasa Section 2, no? Na the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches of whatever nature and for any purpose shall be invited, and so on and so forth, except upon probable cause to be determined personally by the judge after examination, and so on and so forth. Naniniwala po kayo na ito ay nasusunod at hindi nilalabag?
Mahirap po yung tanong nyo, ano po, because if you are citing that provision and therefore it relates technically or legally to searches and seizures, and therefore there must be a probable cause. Now, baka po ang ibig yung sabihin yung mga pangyayari o yung mga developments po dun sa pagtackle ng Article 3 or Article 2, na yung mga certain issues that arose because of objections to how certain evidence, or that, no, not evidence, but certain paper as attached to the request for subpoena, and the sensitive matters with the principles or the rule of non-disclosure of deposits. Now, hindi ho natin wala ho tayong pinag-uusapan na search and seizure dito. I'm not sure if that's what you were, kasi mahirap po nga, very, very broad nga po yung tanong
Madam
nyo.
Secretary, pasensya na ho kayo dahil hindi ko ho ito tinatanong para sa sarili ko, no? Tinatanong ko ito para sa napakaraming nanonood na nagsusumikap na maintindihan at maunawaan itong proseso. So, generally po, timbangin na lang nyo, naniniwala kayo na itong devoid of all the legal and technical aspects, nasusunod pa naman ito. Sa tingin niyo?
Nasusunod pa po yan.
With the permission of the gentleman.
Sa tingin ko po.
Madam Secretary, kaya palagay ko ang tendency ng tanong, the inviolability of persons, papers, and effects. That's guaranteed by the article or section mentioned by the distinguished Senator Judge.
Yung issue kasi kung whether or not na-violate nga po yung secrecy or confidentiality ng mga bank records, ay hindi pa ho natin yan pwedeng hindi ho ako pwedeng makapagsabi noon. Ano po, hindi pa naman ho malinaw eh. Kasi based on hindi ko naman ho kasi masyado talagang na-monitor po yung dito sa impeachment. But yung tungkol nga po dun sa paano nalaman o paano nakuha yung papel na yon na naka-attach dun sa request for subpoena. Now, and therefore, it would go into the issue of the admissibility. Ang subpoena po, sa pagkakaalam ko po, ay hindi naman kailangan na merong attachment ka o may batayan ka. And especially if we consider the fact na because of that principle or the rule of confidentiality of bank records or bank accounts, hindi mo naman talaga pwedeng matukoy kung ano ang mga accounts na yon. So, if there is such a piece of paper na kini-question o pinaghihinalaan yung source, ay ibang usapin po yun. Not with respect to whether or not we can admit the evidence obtained on account of or obtained through the search warrant. Not search warrant, through the subpoena. Wala ho tayong search warrant na pinag-uusapan dito. It's the subpoena.
Madam Secretary, eto, panghuling tanong na lang po. Pasensya na ho kayo, no? Dahil tinanong ko po yun dahil tungkulin ng Department of Justice sa pamamagitan ng inyong mga subordinates ang alamin o i-determine yung probable cause bago ito i-file sa korte. Kaya napakabigat po nito dahil once may probable cause na, tuloy na.
Opo.
Madam Secretary, maraming salamat po sa pasensya ninyo. Thank you, Mr. President.
Thank you. Majority Floor Leader.
Mr. President, Senator Estrada, may you recognize
The gentleman
Senator
from San Juan, the President pro tempore of the Senate, Senator Jingo Estrada.
Thank you. Maraming salamat po, Ginoong Pangulo. Ang aking katanungan lang po ay para sa prosecution panel, si Congressman Daza. Congressman Daza, magandang hapon po.
Magandang hapon po, Ginoong President Pro Tem.
Congressman, matapos ko pong basahin ng Article 7, tama ho bang sabihin na ang nais niyo pong patunayan dito ay yung hindi patas yung pagdedesisyon ng punong maestrado sa mga kaso ng mga arroyo na inihain sa Korte Suprema, particular na po ang temporary restraining order na pinag-uusapan ngayon?
Opo.
Okay. Nagtataka lamang po ako dahil dun sa Article 1 na final nyo po rito sa amin, ay halos may similarity, halos may pagkakahawig. Sapagkat ayon sa Article 1, respondent betrayed the public trust through his track record marked by partiality and subservience in cases involving the Arroyo administration from the time of his appointment as Supreme Court Justice, which continued to his dubious appointment as a midnight Chief Justice and up to the present. Bakit hindi nyo na lamang po pinagkaisa ang bahaging ito sa mga aligasyon sa ilalim ng Article 1, kaya pinag-uusapan rin natin dito yung mga desisyon ng punong maestrados pabor sa mga arroyo?
Dahil po sa yung dalawang petisyon o usaping iniharap laban sa kalihim ng katarungan, hindi pa po nadidesisyonan on the merits. Doon po sa Article 1, ang pinag-uusapan po ang boto ng Chief Justice sa mga ibang asuntong na desisyonan na magmula na sila ay maupo sa Korte Suprema. Nasa aming parat nadidesisyonan mismo yung dalawang petisyon. Kaya iniwalay po ito, napunta po sa Article 7. Dahil ang Article 7 po ay tungkol lamang dun sa mga nangyari o mga bagay-bagay na nauukol sa temporary restraining order.
Kayo ba may plano ba ho kayo magpresenta ng mga witnesses sa Article 1? O hinto nyo na rito sa Article 7?
Pag-uusapan po namin yan. Pinag-uusapan po namin yan. Wala pa po kaming kapasyahan tungkol sa bagay na yan.
Okay. Noong aprobahan po ng